Hi and welcome to LawWiser. As you're aware, with this pandemic, there is also rising concern when it comes to data protection. Companies today are working remotely, and this is also raising concerns for compliances with respect to data protection. Today, we have with us Ms. Ojasvita Srivastava, General Counsel, Securitas AMEA. She's here to guide us on the data protection laws in the AMEA region.
Hi, Sanya. Thank you for having me here. I think it's very important to understand and talk about data protection laws right now and compliances with data protection laws, especially given that because of COVID-19, there is a lot of remote working happening. There's a lot of data being collected. There's a lot of data being stored and being accessed from different locations. This makes us all the more, vulnerable to violations of data protection laws. I think the focus that was there on data protection laws has increased, and COVID-19 has actually helped us move forward in that direction. I'm very glad that India has finally, moved in that direction, and hopefully we will have this new law in place to make sure that we have an equally robust data protection laws as the rest of the region.
So, if you could guide us on the evolving data protection laws in India.
Of course, it all started with GDPR in May 2018. That's when I think the world woke up to such strict compliance with data protection laws. It has gone in the right direction. In India, I would say our data protection law is not as strict as the GDPR, but it pretty much covers the majority of the requirements from the point of view of an individual and the obligations of organizations on how we're handling it. It's similar, but not exactly the same. As far as requirements of permissions or transferring of data outside of India, outside of the region where we are is concerned, the laws are somewhat similar, but not as strict and as stringent in, say, Singapore or in Hong Kong, or for that matter, even Thailand, which is much less strict as compared to, say, Singapore. Overall, I want to give you, we need to have this discussion in the context or in the background that because of COVID-19, there's a lot of remote working that is happening. A lot of people are working outside of their offices. A lot of collaboration is happening online. A lot of data is being collected as a result of that, and that needs to be stored somewhere. Most big organizations that I know already have well-established data centers for the region. Like they have a data center that they're either taking from an organization or they have their own data centers, but very often they are located outside India. So the question arises, what happens when you're taking personal data of somebody outside of India? So those are the kind of aspects that we need to be compliant with. Of course, our Indian data protection law is not yet in force, but it will be very soon. So when you are, as an organization, looking at the data protection compliance, you have to, of course, take into consideration that you will be compliant with the future law that's going to come in. In most of the data protection laws in the region, the strictest compliance that you have is that wherever you are taking the data of an individual, whether it's an employee or a client, you can take it either with the permission of the particular person, or you can take it to a jurisdiction where there is such a strict data protection law as is there in the home jurisdiction. So if you want to take away the data of, say, somebody from Singapore to a data center that is, say, in Hong Kong, in that case, you need to make sure that Hong Kong has a data protection law that is as strict and as stringent as Singapore. So those sort of requirements are there. They are not there under the Indian law, under the proposed Indian data protection law. We have either the express permission of the person who's concerned, or there is a requirement of the law if it's sensitive personal data relating to things like genetic information and political beliefs and religion and caste and all of that. So that sort of data you cannot take out. But other than that, with the permission of the particular person, you can take the data of an Indian citizen to pretty much anywhere in the world. So that is something that one needs to look at as an organization. When you're looking at a region as a whole where you have several countries and you have to make sure that you are compliant with data protection laws, you need to look at what are the requirements, compliances under each of the data protection laws in each of the countries, and make sure that before you build up any kind of an IT system, that you are compliant and you have taken all the necessary permissions, etc., from the local authorities or the people concerned. So there are countries within Africa, Middle East, and Asia Pacific where you have a requirement for taking express permission from the authority, unless you are taking your data to a specific list of countries that the authority has specified. So, for example, in Morocco, if you are taking away the personal data of an employee outside of Morocco, you need to make sure that you take permission from the authority, because they have a list of countries which is expressly mostly European countries where you can transfer the data. So with remote working, with payroll happening online, with attendance happening online, with a lot of collaboration with clients happening online, a lot of this data needs to be shifted out, needs to be shifted to the data centers. But before you do that, one needs to make sure that you are compliant with the local law.